Hello class, in this revision video, we'll be studying about mischief rule and harmonious construction. This is the second revision video and in the first revision video we have already studied about the other two rules of interpretation, that is golden rule and literal rule. I hope it is clear to you. If you don't understand anything, obviously you can ask me. Now, we are doing mischief rule and harmonious construction in this video. Now, what does this mean? Word mean construction. See, I want to make it very clear that construction means interpretation only and nothing else. You can say that these two words can be used interchangeably for this section and they both are synonyms for each other. चाहे इंटरप्रिटेशन बोलिए चाहे कंस्ट्रक्शन बोलिए, मतलब एक ही होता है. डोंट गेट कंफ्यूज. द एग्जामिनर माइट आस्क यू दैट राइट द रूल्स ऑफ कंस्ट्रक्शन. it would mean the same thing as rule of interpretation. Golden construction अगर बोला तो मतलब golden rule of interpretation ही होगा. Okay, I hope it is. Let us start. We are doing mischief rule of interpretation. Mischief rule of interpretation can be said that this is the third rule of interpretation which we are doing after golden and literal rule of interpretation. And the main aim of mischief rule of interpretation is to determine the mischief and defect that the statute in question has set out to remedy, and what ruling would suppress the mischief and advance the remedy. In applying the mischief rule, the court is essentially asking what part of the law did the law not cover but was meant to be rectified by Parliament in passing the bill. Now, understand it with this explanation that, for example, there is a law in front of the court for which the court wants to do interpretation. The court, it is giving an ambiguous meaning. Okay. Now, for example, if we talk about rape laws in India, rape law before the for a rape law, imprisonment can also be given, life imprisonment can also be given, and death penalty can also be given. Now, if the court, and same for murder, imprisonment, life imprisonment, and death penalty can be given by the court. But if the court is confused at whether death penalty should be given or not, then mischief rule of interpretation can be applied, because this rule talks about suppressing the mischief and advancing the remedy. Mischief मतलब क्या होता है? कोई भी चीज जो गलत हो रही है सोसाइटी में, तो ये रूल बात करता है गलत को सप्रेस करना, गलत को हटाना सोसाइटी से, और रेमेडी को बढ़ावा देना, लोगों को ज्यादा से ज्यादा रेमेडी देना. व्हाट इज द वर्क ऑफ द कोर्ट? टू रेमेडी द पीपल, to give remedy to the people who have suffered from any wrong and do justice with them. So this rule talks about this principle only, to give remedy to the people and suppress the mischief. This rule was evolved in the Hedon's case in the 16th century in Exchequer Court in. Now, these are the four primary or fundamental principles, primary rules of mischief rule, which were established in Hedon's case. Now, what was the common law? These I'm just reading and then I'll explain you. What first is, what was the common law before the making of the act? What was the mischief and defect for which the common law did not provide for? What remedy the Parliament had resolved and appointed to cure the disease of the Commonwealth, and the true reason of the remedy. First, I want to make two things clear to you. The word common law and commonwealth. Why these two words are used here? Because this is an English case, Hedon's case, and it was there in England in in 1584. Okay, it was settled by Exchequer Court. So that is why, if you all must be knowing that in England we have common law system, and in some of the country we have, like in Italy, we have continental law system. So because this is an English case, we have written here the word common law. And why commonwealth? You must be knowing that England was once, we were also a colony of England, and countries like Australia, New Zealand were also colonies of England. So all the nations which are colonies of England come under the Commonwealth nation. So this is why these two words are used. Now let us understand it with the rape example which I was giving you and the murder example in Indian context. For example, a court is listening a case related to rape or murder and is confused about giving the death penalty, because obviously it is not written that for every rape and murder death penalty is to be given. Only rarest of rare crime death penalty is to be given. Now, the court will see that what was the common law before making the act. So the court can see, if I talk about rape law particularly, what was the law before the Criminal Law Amendment Act 2013, because that is the latest amendment which we have in our criminal law. So what was the law? That imprisonment, punishment till imprisonment can be given. 2013 एक्ट के पहले क्या लॉ था हमारे पास कि रेप के लिए कारावास हो सकता है, इम्प्रिजनमेंट हो सकती है, मगर डेथ पेनल्टी नहीं दे सकते हैं. What was the mischief or defect which the common law did not provide for? अब क्या दिक्कत थी? 2013 के एक्ट के पहले भी तो देश चल रहा था, बट क्या दिक्कत थी जिस वजह से हमें 2013 का अमेंडमेंट लाना पड़ा? दिक्कत ये थी कि इम्प्रिजनमेंट देने से भी लोग रेप का रेप जैसा बुरा काम बंद नहीं हो रहा था सोसाइटी में. सोसाइटी वॉज नॉट एबल टू सप्रेस दिस मिस्चिफ. That is why we have come up with even more strict or stringent punishment of death penalty. Now, what remedy the parliament wanted to give to the people who have suffered from rape after the 2013 act? They wanted to give this remedy that whosoever would commit rape in the rarest of rare type would be given death penalty. And the true reason for the remedy was to tell people that rape is an offense, very heinous offense, and death penalty would be given. So this is how the court can decide whether death penalty can be given or not to the person, to the offender who has committed the offense of rape. Okay, I hope it is clear. Now, the second rule is harmonious construction. What does this word harmony means? Harmony means peace. Okay. And what does this word peace mean signify? That there is a conflict. हार्मनी का मतलब पीस होता है. पीस का ऑपोजिट क्या होता है? कॉन्फ्लिक्ट, लड़ाई. मतलब किसी दो चीजों में लड़ाई होना. हार्मोनियस कंस्ट्रक्शन का बेसिक मतलब इतना होता है that whenever there is a contradiction between two sections of the same statute or between two parts of the same section, then the whole section should be read and then whatever meaning is coming, that should be interpreted. ऐसे समझिए. समझिए कि हार्मोनियस कंस्ट्रक्शन तब यूज हुआ जाता है, मान लीजिए कोर्ट कंफ्यूज है कि दो पार्ट एक ही सेक्शन के कॉन्ट्रडिक्टरी हैं, मतलब एक दूसरे की ऑपोजिट बात कर रहे हैं या काट रहे हैं एक दूसरे की बात, एक ही सेक्शन के दो पार्ट, जैसे कि बॉडी ऑफ द सेक्शन हो गया और एक्सेप्शन हो गया. कई बार होता है ना, आपने कई सेक्शंस देखे होंगे जिसमें बॉडी ऑफ द सेक्शन भी होता है और एक्सेप्शन अटैच्ड टू द सेक्शन, प्रोवाइडेड लिख के, प्रोवाइजो भी कहते हैं उसे. दैट इज व्हाट, that is saying a contradictory statement to the body of the section. Then how is that section is to be interpreted? That section is to be interpreted on the whole by reading the whole section. Whatever meaning is coming, that should be applied while deciding the case. Understand it with this example. For example, there is a statute called XYZ Act 1992. Okay, and in that act it is said that section 1 में ये लिखा हुआ है XYZ Act 1992 के, that all the people who are there in group ABCD would be class 1 citizen. Okay, ऐसा कोई एक्ट है जिसमें लिखा है all the people who are there in group ABCD Act are class 1 citizen. अब section 1 की ये बॉडी हो गई. The exception attached to section 1 says that, अब लिखा है all the people who are in group ABCD are class 1 citizen provided people who are there who are below 18 years of age in group D are not the part of class 1. अब ऊपर क्या लिखा है? ऊपर तो लिखा है हर एक इंसान जो ग्रुप ABCD में है वो क्लास 1 सिटीजन है. हर एक इंसान मतलब डी के भी सारे लोग क्लास 1 सिटीजन है. नीचे क्या लिखा है? प्रोवाइडेड people who are below 18 years age in group D are not the part. मतलब D में जो 18 years से कम है वो पार्ट नहीं है, क्लास 1 सिटीजन नहीं है. So these two things are contradictory. If you read the body of the section alone and if you read the exception alone, you will get two different meanings. So for the purpose of getting one single meaning, we need to read the whole section. If you read the whole section, then you get the idea, okay, fine, ABC, all the people, group ABC, all the people are class 1 citizen, but in group B, people who are 18 years of age are not the, are someone who are not the part of class 1 citizen. I hope it is clear to you. Just to avoid the confusion which the two contradictory provisions are creating, this construction type of construction is resorted to. Now, the five principles of harmonious construction, or basically four main principles of harmonious construction was resorted in or was given to us in by Supreme Court in CIT versus Hindustan Bulk Carriers. The first is the court must avoid a head-on clash of seemingly contradicting provisions, and they must try to construe the contradictory provisions so as to harmonize them. Court should make peace or harmony between the two contradictory provisions. The provision of one section cannot be used to defeat the provision contained in another unless the court, despite of all its efforts, is unable to find a way to reconcile the differences. The court should find all the ways to reconcile the conflict if it is there, if at all it is there. मतलब अगर कोई भी कॉन्ट्रडिक्शन है एक ही दो पार्ट के एक ही सेक्शन में या दो सेक्शंस के बीच में, तो कोर्ट को हार्मनी एस्टैब्लिश करने का हर एक रास्ता ढूंढना चाहिए. When it is impossible to complete reconciliation, the differences in contradictory provision, the court must interpret them in such a way so as to make the maximum harmony. Court must keep in mind that interpretation that reduces one provision to a useless number or dead is not harmonious construction. To harmonize is not to destroy any. This is the fourth point. I have not written fourth, but this is the fourth point. To harmonize is not to destroy any statutory provision or to render it fruitless. The court should not interpret it such a manner that one provision is becoming redundant or useless or fruitless. Both the provisions should be given its full meaning. I hope these two types of construction is also clear to you. Please go through my notes so that you get a clear idea of all the four types of constructions. I have given the notes also which sir must have shared with you, or which sir has shared with you obviously in the official WhatsApp group. And if you have all my notes, these notes and class notes, or even if these notes, you get a complete idea of all the types of constructions. You can obviously study from your sources, books or internet sources as well. And if you find any difficulty, please get back to me. Thank you, class.